single item agenda today. Today is April 25th, and I'll do a roll call for my fellow commissioners while we meet virtually. Good afternoon, Commissioner O'Brien. Good afternoon, Commissioner Hill.
I am here.
And good afternoon, Commissioner Skinner.
I'm here.
Okay, great. And this is public meeting number 377. We have call to order and we're all set on our streaming. Thank you, Dave. And we'll get started with our single item. Commissioner O'Brien and I are sort of taking the lead, but this is really a process issue that concerns IEB, legal, and all of us commissioners as we make do the important work of determining suitability for our licensees and qualifying employees. A process that often involves confidential information, protected information, and so it's a little bit difficult to navigate as we meet publicly. We balance the need to be transparent with the need to also make sure to ask important questions about suitability. And we've done that in kind of various models, even during my tenure and over the course of the commission's history. So I thought that maybe we would just reset reframe the discussion around the fact that our regulatory process does imagine in many ways that we meet in an adjudicatory setting, but the regulations give a couple of options. Most recently, we did meet in an adjudicatory hearing model for the REIT, and we were able to address the suitability issues that arise in the course of the REIT. And by the way, thank you to Heather Hall for managing that so well. I really had been meaning to say that more directly to you, Heather, but it went very, very well. And then also to Todd for really framing out the process for me so that we could enter into a private session when we wanted to ensure that matters that we might want to discuss are protected, we had a forum to do so. So Todd, I don't know if you want to add in now, or Commissioner O'Brien, if you want to add in sort of the balancing of interests that occur with respect to this process, because of course we've been concerned also about inundating our legal team and not in our IEB team and not making it more onerous. Two, we have to take into consideration that these matters involve an individual's property rights because of suitability, and licensing is so important to them. So there's due process issues. And then there's also navigating an open meeting law setting or public meeting setting, which has a different set of rules around going into executive session, and then the adjudicatory model and making sure we actually can even meet in private. So Todd, maybe all of those considerations have been hard at work. And I think that I just want to express my appreciation for everyone exercising a lot of patience around it as we think about what might work best. So Todd, I don't know if you want to add, and then Eileen, thanks.
Well, thank you, Madam Chair. I'm happy to jump in. Yeah, the regulations do address this issue. There are, as the chair mentioned, a number of options before you. And just to focus our attention, we're looking at primarily 205 CMR 115.04, which is the section of the regulations that governs the determination of whether a new applicant, a new qualifier is suitable or not. And it provides that it's up to the commission to determine whether to initiate a process for a public hearing or an adjudicatory proceeding in making this decision, and goes on to point out that the commission may only utilize the public hearing process with the qualifier's consent. And then, depending, of course, upon which avenue the commission elects to go, there are certain issues that follow. And of course, we've, as the chair mentioned, gone through an adjudicatory proceeding most recently, and we all saw some of the formalities, if you will, and some of the benefits that go along with conducting a review in that type of format. There is formal notice that was required. There was a pre-hearing conference that was conducted amongst the parties. And then, of course, there are provisions that allow expressly for the commission to close such a proceeding to the public to discuss certain issues. And that is all set out in the regulations as well. That's in section 101 of the regulations that addresses that. And then, of course, if the commission elects to proceed in what the regs refer to as a public hearing, as it has done over the past number of times it's reviewed qualifiers, there is a process that goes along with that as well. And that is typically done at one of the commission's open meetings. Notice is offered on the agenda. And then the regulations do require that the report be redacted and circulated in that fashion so that certain confidential information is not shared publicly. So those are basically the two main options before the commission as set out in the regulations. And I'd be happy to certainly address any specific questions or issues that may be associated with either of those approaches, but maybe I can just pause there for a moment and see, Commissioner O'Brien, if you have any items you'd like to cover before we go back to the chair.
No, I mean, I think what the chair said and what you said lay it out. It's a question of, I had gone back through when we were looking at this process to sort of see the derivation, to see if there was any guidance we could get from that. And it looks like in 2014, some of these background checks had been done externally. By 14, we had staff to start doing them internally. The regs were tweaked a little bit in 14 once that started to happen internally. And there was a recommendation. IB would come forward with recommendations of suitable with conditions, unsuitable, or recommending a hearing to determine the suitability. I would assume in a circumstance where they couldn't come up with a recommendation of any other three categories. One of the frustrations I've had since I got here was being shown a report and then told I couldn't bring it in to the hearing because it would be deemed a public record. So having to sort of ask questions, not having the report in front of me. And as we've said before, the vast majority of them are, so-called clean reports where there's really a non-issue, and moving quickly on our part and for the licensee's part is very important for us. But and I joke with people, being a lawyer, being a prosecutor, and just my nature, I go to the worst case scenario and see how are we going to deal with this when worst case scenario shows up. And for me, worst case scenario is that case that may come before us where maybe there's no recommendation or something comes up in the course of it where we really want to be able to go in privately to discuss things sensitive nature to either the applicant or maybe someone else connected to that applicant who's not really in front of us. And what's the way to do that in a way that preserves everyone's rights? And for me, having gone through this a bunch of times, I keep landing on the adjudicatory hearing in a way I'd love to streamline it as much as possible because it seems to fit with how everything is written. It also, to me, the REIT was a good example of allowing us to go seamlessly in and out when we needed to deal with this. Even though I can foresee a circumstance where a lot of this is just done openly and publicly because there's nothing to see here and we talk about it and we move on. But that to me was the most seamless way of doing it. I have some concerns about whether doing it in other ways and going in and out of an executive session would be A, more cumbersome, or B, are we on the same kind of footing to go privately in executive session? Particularly when what we're talking about is not necessarily the applicant, but maybe a third party connected to the situation we want to talk about. So that's where I came down on this. Just in terms of kicking off the conversation, in terms of where we go from here, that's where I come down on it.
Before we go on, there might just be some fundamental questions that you, Commissioner Keller, you, Commissioner Skinner, have that we can help clarify. you've had at least a couple, maybe, suitability reports. You've had them now in the read. You've seen it. Some of the information, as you've heard, has to be redacted because it's protected. That information is somewhat core to our finding of suitability. So there lies a tension in and of itself. When we conduct our hearings fully in public, we literally may be barred from asking questions that are fundamental to finding a suitability. I can say I haven't had an experience where I've made a vote where I have felt that I was limited in being informed. With that said, I'm like Commissioner O'Brien, maybe by training, and just in anticipation of the types of things that could arise, I want to make sure that I preserve the option to ask every question that I'd like to ask. And I prefer not to do it when the bad situation arises. I'm not sure that really is a fair way to do things because it could shed negative light, maybe unfairly, on an applicant. So I would like to have a process that works as seamlessly as possible and as efficiently as possible while preserving our ability to ask every question. Commissioner Skinner, do you have some thoughts, or Commissioner Hill right now? Commissioner Hill?
I have a comment to make, but if Commissioner Skinner wanted to ask a question, because she hasn't been through these as much as I have yet. So do you have any questions first?
Just a basic question. I guess what is the question that's being put to the commission today for purposes of this meeting? Is it whether to review the suitability matters in an adjudicatory hearing, or to continue in the way that they've been heard in the past, which is at a public meeting / hearing? Is that the question?
Well, that's fair. Maybe with a little tweak. I think we have 5 in the queue. Loretta and Heather, 5 or 6 maybe. 5, thanks, Heather. So we have those, and we do need to get to them. I would say that, and Commissioner O'Brien has helped me think about this, that we would probably like a takeaway today to be able to proceed under our regs as written with an adjudicatory model, very similar to what we just did with the REIT, and then assess how either burdensome that is or how that needs to be tweaked, and then return to, if we decide that doesn't work, return perhaps after we maybe re-examine our reg a little bit to what we were doing in the past. I think if we decide to return to the past, we have to really think about the use of the executive session, as Commissioner O'Brien mentioned, and we would probably just need to look at our regulatory framework with a little bit, we're doing reg review anyway. It's kind of the right time to re-examine that. But my thought was, we've got these 5, given the success of the REIT, maybe we could proceed with that. But that's the framing for today, and the answer could be yes or no. But if it's no, I do think we might need to just think about, just take a look in terms of our process as written in our regs.
And just to clarify, it's the decision that will be made today is just with respect to those 5 qualifiers sitting in the queue, and then we would reevaluate. Okay.
So Commissioner Hill's saying no. I would be open to, we could use it like a test case if that helps, but Commissioner Hill, chime in.
Well, I think whatever decision we make today is going to be moving forward for all of these cases before us, to be honest. That's how I understood it to be.
I mean, ideally, yes, because we've been talking about it for a while. And the regs talk about, you have to pick one way or the other. We're supposed to pick one way or the other. Some discussion on whether that's a case-by-case basis or we want to go all in protocol. And we seem to be trending toward defaulting to one process, understanding that we have an obligation to go one way or the other. And it seemed, again, to me, like adjudicatory gave us the flexibility to go faster in and out on those. But ideally, we can make a step forward and start going process-wise from here.
If it's
So can I
helpful-
follow up on that? I'm sorry.
Yes, go right ahead, Commissioner.
So at the beginning of the process of discussing this a few months ago, I think I had the worry that if we were going to do every suitability report that comes before us, that was going to be very cumbersome on us as much as it was going to be on IEB. However, since that time and through discussions and now through a test, if you will, a few weeks ago with the REIT, I found I can never say the word, I said this to Kathy the other day, adjudicatory hearing that we had with the REIT. I found that to be actually very easy to do. We were in, we went out when we needed to, and we came back in immediately. And we were able to discuss what we needed to discuss and ask the questions that we needed to ask. And I don't think it was cumbersome at all. And in fact, I thought it was very efficient, an efficient part of our time. So I'm not even leaning, I'm there, that this is how we should move forward with these suitability reports. If there's no problem with the suitability report, we're going to be basically, and this is, maybe I'm wrong, but we're going to be going in to the hearing for each one. They're going to last 5 or 10 minutes because we're not going to have any questions. And we're going to be able to look at the report beforehand, come right in and vote. But if we do have a question, we can then go in to the session out of public to ask those questions. And I had no problem with what we did with the REIT. I don't know if anybody else did. I thought it was great, actually. So where I was a couple of months ago and where I am today are two very different things. Why I love working in this commission, because we all can ask good questions and learn from each other. So I'm not even leaning, Madam Chair, I'm there. This is how I think we should move forward.
And I appreciate that, because I probably was a little bit ahead of you, maybe because I had been thinking about what I thought was a challenge. But with that said, this has been a very, a very lively discussion, complex. I think I used the word difficult, not difficult meaning just complex. It's a difficult test, a difficult assignment, and we're navigating it based on a lot of history. And just some recognition that the process at one point was fully adjudicatory. I participated in one, and somehow, probably out of efficiencies, it got more and more streamlined. We want streamlined, but we also don't want to give up the opportunity to ensure that we're preserving all the rights for the applicant, as well as making sure we have the right to ask questions that, if we ask them in public, might actually violate a privacy right. So and that is, I can tell you, a real fear for me, to make sure I don't ask the wrong question. But we also want to balance transparency, so being in public makes sense too. With that said, maybe the question I should ask now is, you're comfortable with the structure that you've done some research on the adjudicatory process and the use of a private format. I don't know if you wanted to expound on that at this juncture, because I don't think you've had a chance to do that. We did it a little bit during the REIT, maybe.
Yes, I'd be happy to. Thank you. Of course, under the open meeting law, all business that the commission conducts or deliberates must be done in public, unless there is a specific reason that is allowed for under the executive session provisions of the open meeting law that allow a body to discuss something in private. By contrast, when it comes to an adjudicatory proceeding, there is jurisprudence out there that allows a public body, when sitting as in a quasi-judicial posture, to discuss and deliberate matters in private. And it's outside of the open meeting law. There's, as part of the open meeting law, there's a definition of the term meeting, and it specifically excludes when public bodies like the Gaming Commission are sitting in a quasi-judicial posture. So the first principle that's important to bear in mind is that when you conduct an adjudicatory proceeding, the open meeting law does not apply. But there's a different series and body of law that does apply. And most of it is contained in Chapter 30A, which is referred to as the Administrative Procedures Act. And there is a case in particular, it's called Doe versus the Sex Offender Registry Board, where the Supreme Judicial Court discussed the idea of closing adjudicatory proceedings to the public. And in the case of the Sex Offender Registry Board, there was at the time, and I haven't checked to make sure there still is, but as of the drafting of that case, a regulation in place that essentially said that all hearings of the Sex Offender Registry Board shall be conducted in private for privacy reasons, not just to the individual, but to other folks who may be involved either as a victim or otherwise in a particular situation, that allowed for the body to close the hearing to the public. And they had a regulation in place. And based upon that, the Gaming Commission too adopted a regulation that allowed for the closing of adjudicatory proceedings to the public in certain circumstances. It did not, however, like the Sex Offender Registry Board, call for all hearings to automatically be closed to the public. Instead, it gave the commission the option of doing so. And I don't have it right in front of me here. I can pull it up real quick so we can take a look at what it says. Oh, here it is. If it's okay, I can just read it. It's only 1 sentence, 2 sentences. It says that any adjudicatory hearing conducted under the Gaming Commission's regulations may be closed to the public at the request of either party or on the commission's own initiative in order to protect the privacy interests of either party or other individual, to protect proprietary or sensitive technical information, including but not limited to software, algorithms, and trade secrets, or for other good cause shown. And then it says such a determination rests in the sole discretion of the commission. So it's that provision, which is found in section 101.01 of the commission's regs, that was relied upon in closing part of the hearing to the public in the case of the REIT review recently, and that the commission could make use of when it comes to suitability related reviews as well. So based upon all that, the commission is authorized to do as it previously did a week or so back and close a hearing that is commenced open to the public, close it to the public when it finds that privacy interest or other compelling need is in place to do so. And of course, we will make sure that we have that process down so we follow the reg carefully in every instance. But what you're talking about is completely authorized under adjudicatory proceeding jurisprudence and the commission's regulations.
I have a logistical question, Madam Chair. So if we have 5 of the suitabilities coming before us, do we have 5 separate hearings, or do we have 1 hearing with 5 suitability applications before us? How would that work? Just out of curiosity.
Councilor Grossman?
I think Commissioner Hill, you'd want to conduct 5 separate hearings. There are different interests. I mean, I'm not familiar with the issues that you'd be confronting, but it's presumably 5 individuals who've been reviewed separately, who all have different issues that may need to be addressed. So I don't think you'd want to connect them. There may certainly be situations in the future where you could do 2 together, I suppose, but that would have to be an ad hoc kind of decision. I don't think you'd want to do that here.
And I know we've done this in the past, and I'm just forgetting. If you had an open meeting, those are all separate, if I'm mistaken. Is that accurate?
Yeah, I think the same principle holds whether it's done in adjudicatory fashion or at just a public
Yep.
meeting. I think you'd want to do them all separately. Everyone is entitled to a separate review. Keeping in mind, regardless of which way you do it, it's still the same standard of review. It's the burden is on the applicant to demonstrate by clear and convincing evidence that they are suitable under the statute. And so you'd need to make 5 independent findings either way. It seems to me that you'd want to do it at separate proceedings.
Yep. Thank you. I'm still there, Madam Chair. I haven't changed my mind yet.
So I can offer that, you know, this is to me a matter of process that we want to get right going forward, and so I have the burden that both Makisha and Eileen also carry, which is that law degree and law practice in the background. So I wondered fundamentally what was resting on me and trying to figure out which avenue to go and why one seemed better sometimes than the other and the other one seemed better. And I went and I looked at some fundamental jurisprudence and was reminded that in agencies like ours, we have our rulemaking function. And that's our public, where we do things in the public meeting, where we are the regulator and we're acting as a rulemaking body. And then we have this adjudicatory responsibility, and that's throughout our statute, where we are actually acting in this, rather than quasi-administrative, we're acting in a quasi-judiciary. And the jurisprudence indicated that it's triggered when there's individual rights are at stake. And in every suitability situation, it could be an entity, and I guess that's a little bit different in my mind, but with an individual, if we were to deny suitability, that's a significant impact on somebody's property rights. So it carries more of a burden around due process. And this is where I've struggled. So that's kind of the trigger of why do we do some things in a public meeting context, and why have things been done under adjudicatory model? And the adjudicatory model, when we do it in public, we are preserving the rights to appeal in a way that we are not necessarily preserving automatically in a public meeting. And correct me if I'm wrong, I think Heather, I've asked you this probably twice. I think that they would, if they wanted to appeal, they could have our decision could be appealed administratively again. It wouldn't, right? Before it went to a 30A, it wouldn't be automatic. Is that right? If we denied, there would have to be more process at our level, correct?
Yeah, it's a tricky question. I mean, I think at the end of the day, if it was an open session and an open meeting forum, you would have that option of the adjudicatory proceeding before the commission. And obviously, Todd, if you have any other further thoughts on that.
Well, I mean, either way, typically people have a right to challenge agency decisions. If you conduct a hearing in an adjudicatory format, there's a specific provision of the law that allows for an appeal to Superior Court to review a 30A decision. There are other mechanisms that people could use to challenge decisions that you make every day, or not every day, but at your public meetings. People can take those into court under different mechanisms like certiorari or different things. So there are plenty of instances where people have challenged board decisions that didn't take place at an adjudicatory proceeding. And there are slightly different standards of review, but they're similar, and ultimately the court would still be looking at what process was afforded and what the factual record looks like and what the decision was ultimately based upon. And arbitrary and capricious principles would apply in one way, shape, or form. But yeah, so it does change the court review, but typically people have a right to review one way or the other.
I think that's right. It might just be a different process, and we might have to go through a little bit more process. But so that's where I started to think, why do we even have adjudicatory processes at all if it's not for this? And the REIT really demonstrated to me that we could do it efficiently. So from my perspective, I feel like it's probably the better process for us to engage in. It probably is better aligned right now with the way the reg is written. And I would recommend that we do at least the next 5. And if it blows up, we can gather and figure out how to make it more streamlined. I think I'm imagining, and Akeisha, maybe in your practice, you've seen this. I think I've seen it historically, so my memory might not be great, that we could rest on the report, in a way that would be very streamlined. In many ways, that would echo what we've done with in the public meeting. Commissioner O'Brien, I don't know if you want to weigh in at this junction.
No, I think that's fine. Like I said, I've been thinking adjudicatory is the way to go since we brought this up, I think June of last year when we started the conversation. The only caveat I would put on there is I think we've all agreed there are some parts of the reg that maybe need to be tweaked a little bit. Some of the wording we need to clean up. The public comment, if for some reason there's an option or desire to do a particular one publicly, we need to figure out, do we want to continue to allow public comment? If we don't, we need to amend the reg to say that's not required anymore. So there's some cleanup that we need to think about. But in terms of moving forward, particularly in these 5 that need to be addressed, I think that's the right way to go.
I want to, Commissioner Skinner, I don't know if you want to weigh in now. I'd like to also ask Executive Director Wells and then Director Lilios, and then of course Council Hall. Carrie, I see you're here. We're well represented with attorneys. Everybody should weigh in. It's meant to be a conversation about our important processes. So Commissioner Skinner?
So I think what's missing for me at this juncture is, I need to understand what the considerations are. I mean, it seems, and though you Chair and Commissioner Hill and Commissioner O'Brien have had the benefit of prior discussions around this and a historical perspective, I guess, in my role as a brand new commissioner, I am a little confused about what the issue is. I get adjudicatory versus public meeting, but what is the point of contention, I guess? Why has it taken so long for the commission to come to a decision about the suitability review process? What am I missing, I guess? And I have had several conversations with General Counsel Grossman and Director Lilios, but I guess, in my mind, it seems that, at least Commissioner Hill is ready to take a vote, maybe Commissioner O'Brien as well. But have we fully hammered out all of the issues? And really, what are they? I guess, from the perspective of my fellow commissioners, I guess, what are these issues?
If you wouldn't mind, I'd like to have the Executive Director weigh in, and then we'll go back to our perspective. I just feel like we've talked a lot, but I'm happy to address it more directly. But she raised her hand. So, Karen?
No, I'm just, my take on this is just that it's sort of the overarching theme we've had at the commission for a long time, that, it's always just looking for the best way to do things, even if we haven't been doing them in the past, and we're open to adjusting as we go. And I think it's that natural evolution of how we want to do things. And, we didn't, to Eileen, Commissioner O'Brien's point, we haven't had a concern over any of the open meeting determinations that have been made. Even Chair Judd Stein said she didn't have any concerns about her votes there, but that doesn't mean we can't take a look. And, we are looking at, through this reg review process in general, how do we do things? Could we be doing them any better? And I find it interesting that Commissioner Hill, through the process of looking at the REIT, saw that, he liked that setup where he could go into private seamlessly, and that seemed to be effective. So I don't think it's necessarily something where, because the commission really hasn't finally determine this just happens to be the forum. I don't know if that's helpful at all, and maybe I'll just defer to the commissioners, but just wanted to chime in that even in the IEB, you know, we were always looking at different ways to do things, and can we improve on you know, investigations. And so this sort of is somewhat of the norm for the commission to be reevaluating our processes.
Does anybody want to chime in?
Commissioner Skinner, let me just say this because I consider myself to be very new still. And I can't believe that it's almost 8 months that I've been here. It feels like yesterday I was just sworn in. But what I have found in the last 7 or 8 months, and you're going to find this as well moving forward, is that the way past boards have done things maybe worked very well for them. And they did it very well. I don't have anything negative to say about the way a former board did their work. But as we've been looking at the regulatory, they're in regulations since I've been on this commission, we have seen that we want to do things differently, which is our prerogative. And that's really what this discussion is all about. What's happened in the past 10 years, we may want to do a little different moving forward. It's nothing that they did wrong. It's just that we want to do something a little different because we feel a little more comfortable with it, as they felt comfortable during the last 10 years. That's really what this debate is about, is we're going to be changing the way we do things. It's not worse, it's not better, it's just the way we, if we collectively vote to do this, want to do these particular hearings moving forward. Really isn't any issue that was brought up that's wrong with the way things have been going. It's just, we're looking at this in a very different view than we did, the past board did. And we've made, I think, 3 or 4 changes in the regulations since I've been on that is different than the way it used to be 9, 8, 7, 6, 5, or even a year ago. That's all, in my view. This is what this discussion is about. How do we as a commission want to move forward with suitability of our employees? And it's going to be a little bit different than the way it used to be. And I'm okay with that. And I like the way it is. And quite frankly, if you haven't seen this board, and I've seen from Eileen and Kathy, and this is to be funny, and I hope you take it that way. They ask a lot of questions, and they're very good questions. And under the public or open meeting under this, they wouldn't be able to ask those very good questions. I've learned so much from the questions they ask because of their expertise and experience in their fields. And I think giving us the ability to be able to ask those questions is a good thing for our commission. And again, the commission before us, maybe they didn't want to ask as many questions as we do. We like to ask questions. This makeup of this board, I can see already. So unless someone disagrees that there's a problem, I don't think there's a problem we're trying to fix. We're just trying to do it in a different way that we feel more comfortable with than the board that preceded us. I don't know if that answers your question.
I do want one point of clarification, because I want to assure Commissioner Skinner of one thing. I have not had a conversation with Commissioner Hill about this record at all. Anything that he's saying is coming from his observations about these conversations that have started apparently. I think we saw it was June because we did the minutes, right? I mean, we're reminded. Commissioner O'Brien and I have had the benefit of conversations. We've worked on this with Todd in our legal meetings. So she and I don't believe, Commissioner Brown, you've spoken with Commissioner Hill either. So, you know, I think Commissioner Hill, I'm learning it today. There has been an evolution, and what I'm hearing is that probably the REIT kind of demonstrated it, because I have pointed out my big concern, and it's not just for me, but it is for me too, is that I need to make sure that every commissioner on this commission, whether there's 4 or 5 of us, has at any time the process that supports their ability to ask any question at any time. And I can assure you that in the public meeting setting, even with the executive session, I feel that there will be a chance where you may not ask that question comfortably in a fluid fashion, and maybe not at all. And I feel that in the adjudicatory hearing, all the commissioners will always have an opportunity, whether or not they need it or not, to ask a question that might otherwise be protected. I think that's where I'm seeing my job, Commissioner Skinner. It's about, and thank you, Commissioner Hill, you said it so nicely. It's about us doing our job. And at the same time, my research has now reminded me there are important property rights at stake here for the applicant or the licensee, and that's why there's further support for it. But it really comes down to the asking of questions. So I just first off wanted to make sure you knew we have not had any conversations about it. Does that help on the, when you say contentious, like not contentious, oh, sir, go right ahead.
No, so if I just want to address, so some of it is when you go back and look at how it's been done historically and you compare it to the regs, there's been an evolution. And then you go back and look at when the regs were written, what they were doing. And so even taking the public comment for an example is when they were doing the initial suitabilities on the applications, there were determinations on who was going to get the license, et cetera. And the desire to be transparent was not paramount, but pretty high up there with how the commission wanted to function. So even the reg review that we're looking at, the discussion about what might have been really a requirement for public comment then, we need to consider, do we want to continue that or not? And when we did the deep dive looking at the regs, the question was, there's a decision point in the regs where we as a commission have to choose process A, adjudicatory, process B, public hearing. That choice hadn't been made for a while. Again, they're all fully in compliance in terms of making the adjudication, making it, doing what we needed to do and protecting the rights of the applicants who are coming in front of us. Having said that, though, when you went back and looked through what the mechanics were, the question we then raised is, if we're going to do that and we're going to choose the other route, which is adjudicatory, which we have done, we did it in the Wynn hearings a year after I got here, we started to go down the avenue of, well, what's that going to look like? Is it going to be overly burdensome? Is there going to be an undue burden on IEB or legal, or any rights going to be lost by either the applicant or opportunities for us to fully vet? And so that is what started some of the conversation. And it's not really a change in how we're doing things so much as the regs allow for two different processes. This one has not been used as much as what had been sort of a default public hearing. As I got into this, and again, I was going to worst case scenario, to me, the safer bet for all of us, the applicant and commissioners, was to default more to the adjudicatory process. So that's where I came from about a year ago. But some people were comfortable doing it another way, the feeling they were absolutely covered and comfortable doing it the other way. And so there's been conversation about the pluses and minuses of that. And then we've had turnover, and we don't necessarily want to move forward on a process until we have the people that are going to participate in the process at the table. And so this is really the first time since you've been here, we've had the opportunity to really say, all right, the four of us are going to be here right now. We got 5 on the table. How do we want to do this going forward? So that's why we're here today, a process that started, 10 months ago, but there was a reason it took to evolve and debate and then come in front of the 4 of us who are going to be moving forward with the process.
Mm-hmm. And Eileen, when you mentioned public hearing earlier, you mean the public meeting?
Well, no, so the regs say hearing, not meeting. And so
Yeah,
that's when I talk about cleaning up the language, there's things like that I think we're going to want to clean up regardless of whether we choose to go primarily this route in adjudicatory instead. We still want to finish looking at the regs that are involved in this. For that's an example of one of the things. And then another one, and again, I think about this because I remember that Commissioner Zuniga had quite a bit to comment on when I went back and looked at the June hearing in terms of the public comment component. What does that mean? What do we want it to mean? Do we want it to stay? Do we want to say that's not relevant anymore and have it no longer be a requirement? There are some other things for us to consider in terms of the public hearing route.
But are we seriously considering that there would be this public hearing around suitability and not just, we could, yes, but I don't think that's legitimately on the table, is it?
Well, we have a Regency. We don't know what whether there's going to be an RFA1 process out of that, or maybe RFA1s that come out of any sports betting legislation that may be passed. And then we have to then ask ourselves, are we going to continue this way? Do we want to go back? And again, there's people who've been here since the inception of the agency telling us about how it was to go through that RFA1 process. Do you want to keep public comment for that process, but not for ongoing suitability with a licensee? I mean, I think those are conversations that we can have.
The reg as written right now does address adjudicatory hearing, and I think the way that we're all imagining it right now, with the benefit of Todd's additional research on the private sessions, the second choice probably needs to, it deserves some review, and that's why we do reg reviews. That's we're kind of there right now.
One other question I had was, if we sort of default to the adjudicatory hearing process, how does that, are we then becoming individual fact finders, right? So are there now 4 fact finders as opposed to IEB as sort of one entity conducting the investigation, issuing the report? What is envisioned in this sort of question answer session that may or may not take place in private?
We always have responsibility to come up with the findings and weigh the evidence in terms of the law and whether or not it met the burden.
Yeah.
So whether it's done in a hearing or an adjudicatory setting, it does not change our responsibility under the statute in terms of looking at the evidence and then making our findings.
Okay.
That doesn't mean it, because we function in 2 ways. We're a deciding body, and IEB serves as, for lack of a better word, the prosecutor. We saw that with the REIT. They presented the evidence, they were sworn in, and they were party in the REIT with the other side, and then we were the adjudicatory body. It's the same function, and of course, we're very fortunate because we have the benefit of knowing how strong our IEB is. But I think Director Lilios would agree that when members of the IEB were sworn in, that does allow for any member of the commission to ask questions of all parties. And that's why they were sworn in as witnesses as well. So it doesn't in any way, I guess we have that responsibility. And that's actually one of the reasons why I've had concerns, because I wanted to make sure all the commissioners can always ask questions. And if we're in public, and of course I'm saying meeting, recognizing the reg has some changes that it needs to address. If we're in a public meeting, there are times we cannot ask questions if it's deemed confidential, and even the exhibit in the REIT was deemed confidential. So that means we may not be able to do our job to be able to find if there's clear and convincing evidence to support suitability. Again, as I've said, I've never felt uncomfortable meeting that burden under the processes in the past. But I am right now at that juncture where we're taking advantage of these discussions to say, is it the best process, or is this a good time to re-examine what works best for everyone's responsibilities, IEBs and ours, and the commissions, and the Commonwealth's interests. Is that helpful?
It is helpful. It is, for sure. The discussion is helpful in general. I guess, what else, what other considerations? I mean, it seems so simple and straightforward.
Not simple at all. That's why we've struggled. And that's why I think I've said to Director Lilios, help me understand why I don't understand, or help me understand why I'm wrong. It is to make sure that the process supports us in conducting and doing our job. And as I said to you, Commissioner Skinner, you're looking through a new lens, having been on, an employee and now the commissioner side. It is a new lens. So if you're thinking it's complicated, it is. Yeah, welcome. Sorry.
Well, it is very different, but I'm not thinking it's complicated. I think it sounds really straightforward, but I had, leading up to now and, sort of anticipating this discussion, I guess I just expected a lot more. And I've said this before, and I think I said it during this meeting earlier, is what am I missing here? It seems, do we want to go the adjudicatory, process, or do we want to continue on in the manner that these matters have been taken up in the past? And I guess at the heart of it all is, I guess I'm struggling to see the difference between the two processes. I respect that, the Chair, you feel that there is not a process by which we can ask, sensitive questions in the public meeting process. And that's certainly persuasive, right? That's a reason to go the adjudicatory route. But I do worry that, whether there is an undue burden that's being placed on IEB, on our legal counsel to hold these adjudicatory hearings for every single matter that's up for review, as opposed to just continuing on again, as the commission has heard and decided these matters in the past.
I think that's a real fair concern. I would argue one, even if it were a more arduous burden, the right process is important, right? I think we all agree with that. I feel like we've got a good test case in the REIT that, and Todd, Councilor Grossman did an excellent job of framing it through a lot of pages of my narrative. I think that can be reduced, right? Because we're on these, it's usually one exhibit for each, not 8 or 9 as in the REIT. And there are different considerations in the REIT that requires all the notice. I think nailing down a notice, we have to do that. We have to do that anyway for these applicants. And then, as we said, there may be many times where it feels very much like exactly the same process we did. But we may want to reserve the right to question the applicant if we're lucky enough, and it's a topic for another day, to continue to be able to meet virtually, where an applicant from across the country can come in and be on the sidelines in the event we want to preserve the right to ask questions. I think that might be something that's important that we have lost track of over time. So it might be an enhanced process, but my goal, and I think it can be achieved, is to not make it a burden for our IEB. I don't think anybody's interested in doing that.
Commissioner Skinner, I had the same concern you had about the putting any further burden on IEB, but I heard very clearly today, or at least I think I did, we can revisit this. And in fact, we're going to have to revisit this because, I hope, because the sports betting bill is going to be debated this week in the Senate. And I think we're going to see something by the end of July. And this conversation is going to have to take place again, because how are we going to do the suitability of those facilities and those employees? And it may be burdensome and burdensome. And if that is the case, then we are going to have another discussion. And because of that comment that I heard earlier, that made me feel even more comfortable voting to go the way the way I think I'm hearing my fellow commissioners want to go. We can always bring this back for further discussion, and if we need to make a change, we can do that, as I understand it, unless I'm wrong.
Always. They may take these kinds of public conversations, and there may be a number of them, but we can always and should revisit. Really, it's just a matter of good practice, I feel. Commissioner O'Brien, you want to add in?
No, like I said, I've been in this spot for a while. And I have no doubt again that this conversation will probably ebb and flow depending on the types of things coming in front and, staffing issues, et cetera. But for me, where we stand right now, and this is where I think we should be.
Yeah, it hadn't dawned on me earlier that we would ever consider using the public hearing process, like the true public hearing process, until you mentioned the sports wagering legislation that's coming up and all the RFA ones that we'd have to consider. So that was very helpful. I think, and I hope I'm not putting our staff on the spot, but I think it would be fair to hear from IEB and Councillor Grossman as in terms of what the burden, if any, would be on their staff if we went the adjudicatory hearing route for all of these. Does that make sense?
Yes, I actually invited them to comment, and I don't want to put them on the spot either, but Director Lilias, absolutely.
Sure. I mean, from the IEB's perspective, we're really focused on our statutory and regulatory responsibilities. We are charged with conducting a thorough investigation for suitability purposes and writing a thorough report with our investigative findings and making a recommendation. And all of that is to help you as the commission make your decision about suitability, because that is your decision. So, whatever process you identify as being what you need to discharge your responsibilities in making those suitability findings on this top tier of casino qualifiers, the IEB will be responsive to. I think that's the best answer I can give you. We have had experience with the adjudicatory process, both before the full commission and before hearing officers. So it is something that we know how to do, and we will be responsive to giving you what you need for you to be able to make the decisions that you're charged with making.
If I could just loop in on that, I also just want to comment to the note about whether it will be kind of unduly burdensome for IEB. I don't think it will be. We had a very good flow working with General Counsel Grossman on the REIT proceeding, and it was quick in terms of what we had to do on the front end with respect to the pre-hearing conference. And I think it's a good concept to look at it for the next 5, and as everyone has said, kind of evaluate as we go. But I don't think at this juncture that it will be overly burdensome for the IEB, at least from my standpoint.
And Karen?
I was just going to say, I think someone mentioned it, whether it was Eileen or Kathy. One thing that's a game changer, Nikisha, would be as a result of the pandemic was the technology. And this is more on the licensee perspective. It used to be, if we were having a hearing and the person was going to be there to be available for questions, they would have to, fly in the day before, be there for the hearing, fly back. But now they can just be in their office and they can go on the meeting and, can do it remotely. So as far as burdens on the applicants, the licensees, it's a different world now than it was before. And that I think is part of the equation.
I guess if I can, I'll jump in here as well. I don't like to refer to these things as burdens, but there are some different things that, as the legal staff, that we would want to work with the commission in preparing in advance of an adjudicatory proceeding that we don't do if matters are reviewed at a public meeting. For example, we do need to prepare a notice of the hearing, which of course is very similar from hearing to hearing. So it's not as though we have to set out and rewrite a notice for every single hearing, but we do have to ensure that we're affording the applicant reasonable notice of the issues to be addressed. So we would need to make sure that we have a copy of the IEB's report in advance, and that we're identifying any particular issues that we need to put an applicant on notice of, other than all of the stuff that's just otherwise addressed in the IEB report. We also, when it comes to adjudicatory proceedings, conduct pre-hearing conferences with the parties, and I've typically just conducted those myself or with other members of our legal staff with each of the parties. So we would have the IEB as well as the applicant there, just to run through the process, make sure everyone understands what we anticipate happening, and that we answer any questions, evidentiary or procedural, so that by the time we get to the hearing, we've either resolved any questions that remain, or that we're prepared to address any legal type of issues that may come about. And then the other thing that comes to mind is just the decision. And this is a matter that the commission will have to address, and you can do it on a case-by-case basis as to whether you want to issue a written decision at the conclusion of an adjudicatory proceeding, or just state your findings on the record. Either are entirely appropriate under Chapter 30A, but to the extent the commission would prefer a written decision, that would be something, of course, that we would have to write as well. So those are just some of the things that are different between conducting an adjudicatory proceeding and a public meeting review from an administrative perspective. But again, none of them are overly burdensome or unduly burdensome or anything like that. Certainly, if the commission starts handling all matters or most matters this way, we'll get into a good rhythm and have a lot of templates to work off of when it comes to some of these issues in any event.
I think I should respond to that. I think it's really important, again, for me to reiterate that we're talking about suitability hearings. We're not talking about our regulatory rulemaking functions. We're talking about the right of someone to be deemed suitable in order to have their license and be able to be part of the casino industry here in Massachusetts. And with that comes a host of property rights that attach and are afforded more due process. So I'm not really sure that, the idea of giving notice, I think we have an obligation to do that anyway. We have an obligation to afford the processes that allow a fair process, both for them to be able to give their point of view, as well as for us to ask questions and make it a meaningful process. And that's really where I stand today in terms of the public meeting. I don't believe is the device that affords all the process that we need in order to do our job in any situation. That doesn't mean that we haven't done our job before. So that's why it's completely a process discussion. And in terms of the burden, I do think that once it just becomes institutionalized, it's likely to be really very streamlined. That would be my goal for us as a commission. I think Karen, we've talked about this, and Eileen, you've likened it to some of the processes you've seen in your course of your work as a litigation. I've seen it way back in trial practice. So I'm imagining that it can be streamlined and no one wants to add to unnecessarily to anyone's job. Heather, Carrie, Karen, Commissioner Hill, Commissioner Skinner. Anything further? We're not shutting down the conversation. Really, do you have anything else? Because you are you're coming into this conversation that we've had literally months to think about, stew on. I've had a couple of times where I've been on a tour or something with Commissioner O'Brien and looked at it and go, some point we got to figure out this. So we're kind of figuring this out. We're here today and just saying, again, I think I asked several times, what am I missing? So I laughed when you said that because I actually wondered what am I missing in terms of the complications, because I feel it is the right choice, honestly. I just want to make sure that it's not, as I've said, I'm one of 4 and eventually one of 5. And we have to all really be comfortable with our processes in order to move forward substantively. And the team, like Loretta said, will support us. And again, I appreciate your sensitivity around burdens, because that's been one of the main concerns for myself. And I think Commissioner O'Brien, I don't want to speak for you, but I think you've been really sensitive to that issue as well. Commissioner Skinner?
Yeah, no, having heard from the team, I think, any concerns that I might have had about going all adjudicatory, have been, eliminated. I think that it makes sense if that is the consensus. I think it makes sense to move forward in that way. But it seemed, again, so straightforward. And I will say, what a shame that it took so long to get here, because those 5 qualifiers that are sitting in the queue have been doing just that, sitting.
Yeah, I mean, just remember that different compositions of boards have different views.
Absolutely.
They're not going to change. And so we have a constitution of 4 now that we need to decide as a body of 4 how we want to move forward.
Yeah.
And what may seem like consensus and no questions for us may not have seemed quite that in the past.
Understood. And that was in no way meant to, disparage any current or former commissioners, just stating, I think what I think is obvious, right? It was so easy for us to get to this point today. And I'm pleased by that.
Well, thank you. Maybe it's because it took us a little bit longer, just articulate it. And when I said it's complicated, I think it was complicated to make sure that, from my perspective, that I wasn't wrong. I wanted to really hear our team and make sure that we honored all the processes that have been done in the past, and now, as we said, maybe tweak going forward. And you know what? Future commissioners are probably going to tweak us. So that's the benefit of being an appointed official. So I don't know. Let me just see. I took down the agenda. We did mark it up for a vote. Should we do it this way? That if I'm hearing correctly, we have a consensus to proceed at the very least with the next 5 and mark them up. How we mark them up, I don't remember, Councilor Grossman, if an adjudicatory hearing has to be on a separate day or anything from a public hearing, but I think we could mark up 5 different adjudicatory hearings on the same day in some kind of a sequential order in terms of timing. And I'm absolutely fine, and I hear Commissioner Hill saying I'm all set to make this a process going forward. But I suspect, Commissioner Hill, if you saw something that went awry, we would go back and tweak it. My hope is that for these 5, it serves as a good process for us, and not a burdensome process.
The only follow-up I would have is one of the concerns expressed too in terms of going adjudicatory as opposed to a public meeting is we want to be transparent. And so whether we just discuss process in terms of, is it administrative update, an IEB administrative update, in terms of saying that they're queued up for consideration and or they've been approved, I think is something we want to think about making part of our process, just to continue with the transparency that we're doing this in a way that protects rights and allows us to ask our questions, but we're also being transparent about, the people coming up in front and under consideration and who are going to get a determination on suitability. So Karen, I seem to be
Yeah,
the-
I think that you are correct, and I would recommend, just as part of the administrative update, we could routinely do that. I guess one question, maybe I misheard someone along the line, is the expectation that we would have these in a public setting and then go to a private setting if necessary, or what is the thinking on that?
Well, I just thought that I would clarify that too. In my mind, and this is just how I've thought about it, so I'll chime in, that we would start in a public, because I think it's really important for transparency. I think just as we did in the REIT, IEB could present its report and recommendation, and in many ways, we could then go into private session to decide if we need to ask for more evidence. And if it turns out that we didn't anticipate having the need to have the individual on call, but something came up, let's say, oh, unexpectedly, I really wish I could ask a question, we could, of course, continue the matter and bring the individual back in for questioning. We'd be able to ask any clarifying questions of counsel if they're available. If we hadn't reserved that again, we could continue. I think the practice should be for these 5 that maybe we err a little bit on more process and see how that feels, that an individual would be available for questions. We go into private session, and at the very least, we can thank them. At the very least, we can thank them for their application and say we have no questions. It's just, I mean, that could work if it's virtual. And then if we have no further questions, then we would close it out, right, Todd? And we would do, as we've done in the past, a private deliberation where there's no one else available in the room except legal. But so there are different, this would be keeping it private but open for further evidence, and then moving into, I don't know if that's more process than what we're imagining to have the individual qualifier available during 1 hour by call or by a virtual platform. I think we could do it over the phone too, or maybe we can't I don't know the answer to that legally, if they've been sworn in or whatever. What do you think? Anybody else have thoughts of, but it starts where IEB and does all its good work. And then ultimately we deliberate in private so that we can discuss anything that's, I mean, some of these matters are actually protected by law. Others are sensitive, but we could ask those in public. So I'm not so, hasn't been the issue so much as more the information that is protected, and particularly when it might be not only about the applicant, but about a third party. And that third party isn't protected even through the executive session.
I mean, I think what you'd have is almost like a docket for the day in terms of you can put the 5 on, they've each got a time slot, you follow that process, and you IEB and or the GC group would keep whoever the applicant is on call, unless we knew in advance we absolutely wanted to question someone, and then obviously they'd have to be on and available to us, but otherwise having them be reachable so that if we did have questions for them, they could hop on is probably and then it'd be very similar to how we've been handling it otherwise.
I suppose we could, when you say if we absolutely know we want to, or we know we don't want to, Todd, we do have the alternative of doing a private session where we basically do like a pre-hearing to decide who we want to hear from. And in the process, that's part of the adjudicatory process too, right? Rather than, I know at one point we were thinking about doing that in the agenda set process, which it's hard to speak about the private issues if they're protected issues in any public setting. So is that another way to help streamline the process, Todd?
Yeah, I think so. I think you could meet up to discuss pre-hearing adjudicatory proceeding issues, and one of them could be, do we want this individual to appear or be on standby? And are there any other witnesses that
Right.
you would like to absolutely hear from? Or besides some of the issues flagged in the IEB's report, is there anything else you want the witnesses to be prepared to address? So yes, I think that is a viable way to do it.
So that might work. We had a preliminary process matter that we dealt with in that fashion with the REIT.
Chair,
Yes.
my imagination of the process doesn't differ from yours, I don't think, but did you say that we would start in public, but then go to private even where there are no questions that we need to ask of the applicant? We would just do that as a matter of routine towards the end, even if it's just to thank them for their application?
Well, if we do the pre-hearing process, that might be really helpful. But I think I'd like to be able to reserve the opportunity to go in private, just in case somebody develops a question that they didn't anticipate. And I suppose if that person's on standby, then they could just be excused by legal. If we just say, no, we're all set, then we don't have to. But I was going to say, if we wanted to go into a private session and to just touch base with something and say, but we aren't really opening up anything further in evidence. The worst case scenario is we thank them for their time. But we don't have to do that if we did the pre-hearing, I think. But I do think we want to reserve the right to go into private for any question or additional information or evidence. Like we did that exact thing in the REIT. What did we do in that case, Todd? We didn't go back into private. Everybody just said, no, I'm all set. Okay.
Right. Yeah, I think you actually asked whether anyone had any follow-up, and everyone said no. And
Well,
that
then
was it.
Right. Does that help? That's probably a clarifier, Nikisha, I think, because you're right. You don't want to hold somebody up and have that process, but I just want to make sure that right through the end before we close out evidence, that any commissioner can ask any question. My guess is that it's going to be streamlined in many ways on most of these reports. We're all going to go, nope, all set. We're even faster. That was a really good question, because I was sort of speaking out loud as we're going along. Any other clarifiers or? So do we just want to not have a vote necessarily, but move on consensus that we, at the next agenda setting, look at our schedules and figure out when this will work for the other parties? Director Lilios, does that make sense to you from your perspective? And Heather, Councillor Hall?
I'll defer to Loretta first.
Sure, I mean, I think the IEB would be able to, in terms of its scheduling, be able to do that. And, with depending on who you want to hear from the qualifier side, we can have follow up with them about making sure they're available.
And on that note, I think it might make sense to do the first 3 that were submitted first. And then I know Commissioner O'Brien talked about a docket for all 5 on the same day, but I think it's probably more realistic to have those first 3 that were submitted initially and then go from there, if that's okay with the commission. Because there would be, we would need to loop back with the IEB investigators and make sure they're all ready to discuss the report if anyone has any questions, and also connect with the qualifiers themselves and their representatives if necessary.
Yeah, I was just doing it more to move them along. Even if we did a morning and an afternoon date or something, whatever it takes in terms of now that we know what we're going to do, it feels like we can execute it as fast as you guys feel like you can be ready.
Yeah, I think it could
We
be.
can connect with those investigators between now and the agenda setting meeting, so we can see what the agenda. Okay. Okay.
May I recommend that we don't do it on an open meeting day, that we would do it by itself, maybe?
Absolutely.
Yeah.
And I'm wondering if that's actually a rule. I don't know if I read that at some point that couldn't be on the same day, and I don't know if that's the case, but
I don't think so.
maybe it's just my own rule that that's too much. So I agree. Yeah, it'd be on a separate day.
So in terms of no vote or vote, I'm just looking at the reg 115.04.1 that talks about commission shall determine whether to initiate process for either public hearing or adjudicatory proceeding. I am assuming, Todd, us voicing consensus satisfies, the commission making a determination. Doesn't seem like we need a vote. We've determined it by consensus.
I'm
I
happy
think-
to have a vote.
Yeah, I mean, either way, I think taking a vote would be perfectly fine and a good way to document the decision, at least for these next 5. So yeah.
Commissioner O'Brien, do you want to make a?
I just talked myself into having to make a motion.
Well,
Keep my mouth shut.
So before you,
nice going.
so before you make that motion, we've brought it up a couple of times today. I'm going to bring it up one last time. We're going to be discussing this again in the very near future, I think, which means we may be changing our vote. I'm
Well,
not saying, you see where I'm going with this?
Todd said, well, I think that's why Todd kind of said you might want to stick to the 5 we know are in the queue ready to go. And then if we need to revisit, we can revisit in terms of saying, yes, we're going to keep doing that. Or, you bring it up on something else.
Yeah, and sports wagering, of course, is whole other ball of wax. I mean, you'd have to make these regulations applicable to sports
Right.
wagering, which they're not at the moment, and you might want a totally different process for that. So yeah, I agree.
Or
will certainly have to
it's just
review
that
this.
we're going to be defaulting to, we are making a determination to default to the adjudicatory hearing, absent a vote to the contrary.
And also, honestly, I'm not even sure that it has to be different for sports betting, quite frankly.
No, it may not, but I think that's, I mean, the Commissioner Hill's point and what I was saying before is when you go back and look at how they functioned with the RFA ones and how transparent they want it to be, I think we as a body want to have that conversation before we decide definitively.
Absolutely, yeah.
Okay, thanks.
So with that, Madam Chair, I move that the commission make a determination to initiate suitability processes via the adjudicatory proceeding consistent with 205 CMR 115.04 sub 1.
Second.
Thank you. Are there any further questions? And to all, thank you very much for this discussion. It's really, really helpful for me personally, so I appreciate it, but I think hopefully it'll be good, moving forward. So thank you. All right, Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
and I vote yes. 4 ayes. Thank you so much. And that is our sole agenda item. I always kind of like the single agenda item. It's the luxury of speaking about one thing. So thank you, everyone. We can move to adjourn. I have a motion.
So moved.
Second.
Any questions? All righty. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
and Commissioner Skinner.
Aye.
And I vote yes, 4-0. Thank you, everyone. Appreciate all the time.
Aye. Thanks, everybody.